So hello guys, what's up and welcome back to my YouTube channel. It's me, your girl Barrister Neze, and this is Nezeville. In our previous video, we began breaking down Churchill's statement following the news that Rosy had filed for a divorce, seeking to dissolve their 5-year marriage. We went through everything he said, and I bared my thoughts and gave my candid advice regarding owning a man's fight and inheriting his enemies, especially when those enemies are members of his family. If you haven't seen that video, this video is sequel to that one, so I strongly advise that you watch that one first. In today's video, we are going to be addressing the gongwaso, the cocoa. We are going to be addressing thoroughly the two contentions that Churchill raised in that post. Make sure you watch this video till the very end, because it's in the second part of this video that I am going to address the crux of that publication, that we will be able to finally know if truly, legally speaking, Rosy is his wife or just a concubine, as he is now alleging. The second leg of this video will address whether he is right or wrong and what the law says in this position. If you are new here, you're seeing my face for the first time, or if you've been watching us without subscribing, don't forget to hit the subscribe button, or take out a minute. It is down there. It is free of charge. Hit the subscribe button. It is a fantastic way of letting us know that you belong here. You are a shareholder here and you love what we do. Give the video a big thumbs up. Drop your thoughts down in the comment section. Join our premium channel. I don't think I have really broken down all the perks and benefits of being an exclusive channel member. Now, aside from having access to those premium videos that I make just for you, another perk is that you get to suggest the particular videos and topics that you would like me to cover, and it will be up there highly considered. Like this video, I didn't intend doing it, but an exclusive member reached out and said, Neze, we want to know the legal implications of this particular thing. And I'm like, it is now still news now, let us move on. And she's like, no, Neze, I want to know. And yeah, as part of the perks of being an exclusive member, of joining our channel membership, you get to suggest the videos, the content that you would like me to address, and I will be at your service if it is something that aligns with what we do. So let us proceed with this video. The first bone of contention that Churchill is alleging that we are going to address is the part where he said, let me just read it very briefly. Beyond that, any legitimate legal process requires that all parties be formally served and given the opportunity to respond. I was never served, so I ask a simple question. What exactly is being presented to the public, and how was it obtained? I am 100% sure that individuals without proper experience in the media space are advising Rosy incorrectly, alongside legal practitioners who operate under a mango tree. This man, his mouth is not good. Without due process, and claim to produce divorce documents within 24 hours. Looking at the alleged hearing and judgment dates, I am left asking, is this even possible in Nigeria? So let me address first the part where he said he wasn't served and a divorce just happened. What is the position of the law? What does the law say? There are two principles that govern every trial, every proceeding, and every proper legal system. And they are called the pillars, the principles of natural justice. The first one is called nemo judex in causa sua, and it means that no one should be a judge in their own case. So where a judge hearing a case of an accused person is his father or his mother, or the judge is a sibling of a victim that the accused is standing trial for hurting or killing, that makes that judge a judge in their own case. And no matter how beautifully heard or delivered judgment is, that whole proceeding contravenes this principle that no one should be a judge in their case, and that judgment is null and void. It will certainly be set aside upon appeal. Now, that is the first principle. You can't be a judge in your own case. Nemo judex. The second pillar of justice, of natural justice as we call it, is the one we call the audi alteram patem. These are Latin maxims. Remember that ancient Rome developed one of the most sophisticated legal systems in history. So you find so many even legal terminologies and maxims that we use in Nigeria in Latin, right? So this audi alteram patem means that no man shall be condemned unheard. And when I say man, of course I mean man and woman. No one shall be condemned unheard. It simply means that every party in a case must be availed a fair chance to explain themselves. And that is why some people wonder, we caught armed robber, we caught this person shooting, killing somebody, so why are you taking him to court? What is he trying to defend? Audi alteram patem. He still has a right to explain, and that right is not negotiable. And just like the other one, the first one of a judge cannot be a judge in his own case, any judgment obtained when a party was not given a fair hearing, a chance to state their own case and defend themselves, is also as good as useless. It will be set aside on appeal. This principle of fair hearing is so important. It is so important that it is enshrined in our constitution, our grundnum, under section 36. And it is not limited to just criminal proceedings. Are you listening? It is not limited to just cases of murder, rape, armed robbery, kidnapping. No. Even in civil cases, like trespass, like breach of contract, like divorce that we are discussing, whatever the case is, the principle remains the same. Failure to afford a party the opportunity to be heard negates the entire proceeding. And this second pillar, this one of not giving a chance to be heard, not being served, is the one that Uncle Churchill is raising questions about. I was not aware. I was not served. So legally speaking, what is the position? There are two steps for availing fair hearing. One is to properly notify the party of the case against them. And the second one is to then give them an opportunity to respond, to defend themselves. So when it comes to court cases, processes, proceedings, the subject of notice is core. It is a foundational procedural requirement. Failure to properly serve a respondent with a divorce petition can have very, very serious legal consequences. In fact, in many cases, it can undermine the entire proceeding. So, how is this done? How is this notice supposed to have been given to Uncle Churchill? He is not supposed to just hear it on Instagram or Instablog. What does the law say? The law says that the petitioner in divorce proceedings, a petitioner is the one that says, I no one marry again, the one initiating the divorce petition. The petitioner approaches his or her lawyer, say the whole thing. This is he did this, I no one marry. The lawyer would then go to the appropriate court and file the divorce petition. That petition is supposed to contain several important things that if it doesn't contain, the whole process is cancelled. It's supposed to contain the name of the parties, the date and the place of the marriage, the children of the marriage, if any, the grounds for divorce. What are you alleging? Why do you want to divorce? And reliefs sought. If you're seeking any relief, like child benefits, like property, whatever, all the reliefs you are seeking. For those that are seeking compensation, damages for adultery against the third party, that is where you state all of them. All these ingredients must be in the petition. And then the lawyer, your lawyer, will then go to court to file that petition. The registry will then assign a suit number to that case and prepare the service documents. and the court bailiff. There's a court staff whose designated responsibility is to go and give the Churchill and the likes. So the church bailiff is supposed to take those documents to the respondent, in this case Churchill. So no, it is not the petitioner, it is not Rosy in this case that is supposed to serve personally. The law knows that if it makes it the petitioner, if it's the person that is initiating divorce that is supposed to go and be serving, people will be dying on service days. So there is an assigned court staff that does the service. Service of divorce processes is supposed to be done personally. You're supposed to go and physically give that person the notice of divorce, hand it over, and make him or her sign an acknowledgement receipt with date and time, place of service, and then the respondent is given a period of time to respond or answer the petition or to ignore it. Oh yes, you can ignore it. As long as there is evidence of you getting served, you can ignore it. The process will continue with or without you. I'm sure some of you at this point will be like, Barrister Neze, what if we don't know where the person is? What if the person has gone to another country? What if the person... The law, in all its wisdom, makes provision for that. And in the case where that respondent cannot be found or is deliberately evading service, just like people like UNBROKEN, we covered that in the case of UNBROKEN, where he refused to take receipt of the divorce petition, then substituted service can be used. But you don't just automatically use it. You need to go back to the court, inform the court that personal service has failed, apply. That's asking the court's permission to use another method. So substituted service is with leave of court's authorization. So the lawyer would approach the court again and he's like, oh God, George, this person no one collect divorce petition. Oh, treat my client right. Oh yeah, divorce her. Oh no. Which one we go to? Simisi wahala, and the court will be like, okay, don't worry. The law understands that people like that exist and there is an alternative. The judge will then order for alternative service to be used. Like, what are the ways alternative service can be used? Like posting those documents at his gates. His whole neighbors will read that he's about to be divorced. Yes, you paste it at his gate. It can be mailed to his workplace. It can even now be delivered via social media means. Yes, the law is evolving. It can be sent to you via DM or email, depending on what the judge directs. And once it is shown that this service has been done with through either personal or substituted means, the proceeding can go on with or without that respondent, and judgment can be given. And that respondent cannot later come back and say he was denied fair hearing because he was availed an opportunity, even if that opportunity was not utilized. But in this case, Churchill is saying that he was not served at all. He was not notified. He had no idea that his wife had taken him to court to divorce him. And although we couldn't lay hands on the full document, the full divorce documents, from the little I saw, I'm seeing enrollment of judgment, which looks more like a court order, like a post-judgment document that has already been heard or considered by the courts, almost looking like the divorce has already been granted. And I'm wondering, because that's a bit strange. In all my years, I'm yet to see a divorce process that was filed and within, what date was it filed again? Was it not just April? And within 1 week, less than how many weeks? Divorce was granted. I'm yet to see that. No matter how accelerated the hearing was, I'm yet to see a divorce that was concluded within 1 week. We are following up with the case of May Edochie here. It's 3 years, yet divorce has not been granted. They're still in court. So, legally speaking, Olakunle Churchill is 100% right on this one, that the time frame between filing and judgment is rather unusual and suspicious, and that his right of fair hearing was infringed upon. Now that is the first leg of his allegations and assertions, if I can call it more appropriately that. Now, let's go to the second point, which a lot more people are interested in, are curious about. Throughout the 5 years of Rosy and Churchill together, they performed sweet husband and wife goals on social media. Rosy quickly ran and changed her name, added Churchill's surname. She would take to social media, oh my husband, get you a husband like mine that will spoil you like my own. My husband, get you my husband, I'm cooking pounded yam for my husband. Oh my husband. Olakunle Churchill as well addressed Rosy as his wife, my wife. Oh, the best thing that's happened to me, my wife. So a lot of people are confused now. Now that Kasala has busted, wind has blown, Fawunyash has opened. A lot of people are confused. What is going on here? Olakunle is now saying that Rosy, in fact, let us read this part just a second. He headed it false divorce claims and public misinformation. There was no legally recognized marriage. There was no church wedding and there was no court wedding. What took place was just an introduction. Therefore, the idea of a divorce is baseless from the outset. There was no legally recognizable marriage. So what is the legal position on this his assertion? There are 3 legally recognized forms of marriage in Nigeria. I want you to listen very closely. If you need to jot it, go and jot it, because as I keep telling you, we're not just here to gossip about these people. We are here to learn and equip ourselves and empower ourselves, because knowledge is power. The first form of legally recognized marriage in Nigeria is the statutory marriage, aka the marriage under the Act. It is conducted in a registry, what we call courts. It's not actually in the courts where people are tried. They don't do it in the courts. Not my people that call it court wedding. It's not done in the courts. It is done in a marriage registry or in a licensed place of worship, what we call church. So that is why we call this kind of marriage court marriage or church marriage. It is governed by the Nigerian Marriage Act, and its key feature is that it is strictly monogamous. So a person in a statutory marriage cannot legally marry another person during the subsistence of that marriage. And that is why you find me referring to any woman who attempts to marry a man who is statutorily married as a concubine, because that other thing does not exist as a marriage legally. Any attempt to do that is not only a criminal offense, matter of factly a felony, but such attempted second marriage is deemed a circus at best. Now that is for the first kind of legally recognized marriage. The second one of legally recognized, I'm trying to use Churchill's terminology because he said we didn't do any what? Legally recognizable marriage. The second kind of legally recognized marriage in Nigeria is the customary marriage, aka traditional marriage. And that marriage is conducted according to the customs and cultures of a particular ethnic group or community, people. Some of its core non-negotiable features is family consent. Yes, family consent must be sought and obtained. Remember that in statutory marriage, I didn't mention family consent. Both of you can go. My mother does not like you. My father does not love you. To hell with them. It is us against the world, you and me against it all. You go to courts. They would wed you. What you need is witnesses, and those witnesses do not really need to be your parents. But in the customary marriage, remember that customary marriage is not a joining of a man and a wife. It is a joining of families. So family involvement and consent is paramount. That is one of the features, the key features. Secondly, the payment of the bride price or dowry. That is the fulfillment of the traditional rites. Very integral. And the third is the official handing over of the bride. So if you've attended the traditional marriage, after the rites are done, you see the family of the bride will take the bride and hand her over to the groom's family, not even to the groom. The groom is a backbencher when it comes to customary marriage. They hand over to maybe to the eldest man in that family. So that is very significant. It solidifies that whole process. And of course, this kind of marriage can be polygamous. Do I sense some confusion there? Some of you may ask, Neze, I know you are very clear, you're a good teacher, but you're beginning to confuse me. Which one are you talking now? You said the first one is strictly monogamous, legally speaking, and the second one can be polygamous. So we that we usually do the whole of them, all three. So which of the rules will govern that relationship now? Since we did court, we did white, we did church, we did traditional marriage, which law senior which one? It is simple. Due to the superior legal authority of statutes. Statutes are the written law made or adopted by the legislators. Due to the superior nature of statutes, in the event that the customary law clashes, is not in conformity, consonance with a statute, the statutory law takes precedence. So even if you conducted the traditional marriage, as long as there is a subsistent statutory marriage, the dictates, the rules of that statutory marriage overrides, supersedes those of the customary marriage that allows for polygamy and all of that. So if you are polygamous in nature, don't wed in the church. I don't even know what you are going to church to do. You cannot serve two masters at the same time. Go to your village shrine and marry. You cannot go to church and say two have become one. What God has joined together, let no one put asunder. Then you now go and bring someone to put asunder. Are you normal? Are you well? You cannot be a traditionalist and be a church goer. Leave church alone and go to the village and have your traditional marriage. And the woman that sees that you have refused to do the other one understands what she's getting herself into. And there are several women who do not have a problem with it. Go ahead and marry 10 wives. Comprehende? Comprehende. Gracias. Now again, I need to categorically, if you are understanding what I'm saying, if you are learning, begin to drop down in the comment section and say, yes, Neze, we are learning. And don't forget to join our premium channel if you're yet so, where we discuss so many things around marriage, life, relationships, self-building, self-worth, and so many things that will add value to your overall quality of person. You can join by scanning this code over here or simply joining here on YouTube. Very straightforward. You see, just beside that subscribe button, you see join there, exclusive channel member, and get all of these perks available to you. Now again, I want to hammer on something here. I need to categorically state here, for those who may be confused, which may be where Churchill may fall under, that just because this kind of marriage, this traditional marriage I have described, was not conducted in a legal setting at the registry, does not mean it is not legally recognized. It is legally recognized by our law. So even if this is the only marriage you did, you are in a legally recognized marriage. The rules, the protection, and the consequences may differ from the statutory marriage, but that does not mean that it is not a recognized marriage by law. It is. Traditional marriages are completely legally recognized. And then, of course, the third kind of marriage, legally recognized in Nigeria, is the Islamic marriage, common with our Muslim brothers and sisters. And some of the key features of an Islamic marriage is the offer and acceptance and the presence of witnesses. Just like the traditional marriages, it can potentially be polygamous as well. All three marriages aforementioned are legally recognized unions. So, if what Churchill meant when he said there was no legally recognized marriage is that there was no church wedding, that there was no court wedding or church wedding, as he said. If what he meant is that since there was no court wedding or church wedding, what we have is not recognized by law, that a traditional marriage is not legally recognized, then he is completely wrong. A marriage did exist. A legally recognizable marriage did exist, even if it was only a traditional marriage. But if what he is saying is that traditional marriage that is legally recognized didn't even hold at all, that it was just an informal introduction, no traditional rites were conducted, no bride price was paid, there was no official handing over of the bride to the groom's family, that's what they just did was, I want to know your people, then he is 100% right. There was no marriage. Because remember that when I was describing a traditional marriage, I mentioned key features, and any traditional gathering where these rites were not done is not a traditional marriage. Because I have found that this word introduction can be used very loosely. In some places it carries more weight depending on the cultures. For some places it doesn't carry much weight. If the introduction he means is that they were given a list, he bought what was on the list and performed the rites under those lists, whether it is called introduction or whether it is called they do small thing for my head, whether it was done in the living room or sitting room or compound or primary school hall, wherever it was done, whether there was an after party or not, as long as those rites were fulfilled, family consent on both sides were obtained, the bride was handed over, that is a legally recognized marriage under the Nigerian law. And he cannot claim that they were not married. They were married, if that is the case. Lastly, before we bring this video to an end, the type of marriage conducted also determines the type of dissolution and where this dissolution can be sought or obtained. For a statutory marriage, which is the court or church marriage, the proper place to dissolve it is in the courts, at the high courts of the state. You cannot only go and return a bride price after conducting a church wedding and you say you are divorced. You are not divorced. You are very, very married. Likewise, you cannot have only a traditional marriage and then go to the high court to asking them to grant dissolution of a traditional marriage. No. Traditional marriages are dissolved traditionally, just as they were initiated. So, just as family involvement was very central during the formation, it is also very central during the dissolution of a traditional marriage. Both families will first meet. Reconciliation will be attempted. And where reconciliation fails, then bride price is returned. After bride price return, there is then a public acknowledgement that the marriage has ended. Nothing hold both of us, nothing hold these two families together. Our son and your daughter are divorced. So, just as the payment of the bride price is crucial in the establishment of a traditional marriage, the return of the bride price is also very symbolic. When I say bride price, I don't mean everything on the list. So there is a list and there is the bride price. The list, that one, it cannot be returned, my dear brother. All those cows, goats, rapper, 12 yam, gin, all those ones are not, they're not up for return, okay? What is returnable is that amount, the bride price itself. But in the event that during this dissolution, there is family conflicts, the family cannot resolve, they are clashing, there's some families would even refuse to accept the bride price. If there is all of those problems, then the person seeking the dissolution of that union can then go to a customary court to dissolve a customary marriage, not a high court. There is an alternative way. So you can either dissolve traditionally through family, or the person seeking for the divorce can go to a customary court to dissolve that customary marriage, not a high court. So I couldn't quite see the heading and the words of that petition or that judgment. But if Rosy filed in a customary court, and that thing that Churchill is describing as introduction not legally recognized, her bride price was paid, then Rosy is absolutely right with the steps she is taking. But if she had filed in the high courts when there was no statutory marriage, then she's on a long thing. Churchill becomes right. So you can see that both parties could be wrong, could be right, or could be wrong and right, depending on the situation or the real facts of the case. I do hope that we are learning and taking things home from this whole incident and these videos we are making to address them. If more information comes up, you can be sure that I will let us know. So guys, yes, we have come to the end of today's video. If you are new here, you're seeing my face for the first time, or if you've been watching without subscribing, don't forget to hit the subscribe button, give this video a big thumbs up, drop all your thoughts down in the comment section, and stay glued for we have so much more coming your way. If you have learned something, don't forget to say, thanks, Neze. I just want to see that engagement down in the comment section. Give us a thumbs up, subscribe to the channel, grab a copy of our book, The Unbroken Spirit, where we candidly discuss a lot of issues around marriage and relationships, especially when it comes to abuse, mental health, rebuilding, and so many things. It is a must read. You can get soft copies on the first two links. For those who want the hard copies, that can be gotten only via the Amazon link. Thank you so much guys for watching. I'll see you guys in our next one. For now, bye.